Thank you, Professor Liu, for coming and bringing your family to join us today. I'd like to start out by talking a little bit about the Commerce Clause. On page 72 of your book, Keeping Faith with the Constitution, you wrote as follows: "The court has declared certain subject off limits to federal regulation by attempting to draw a line between economic and non-economic activity," referring presumably to the Lopez and Morrison line of cases. Mm-hmm. A line that looks much like the old distinction between what directly affects commerce and what touches it only indirectly, in its incoherence and inefficacy in advancing federalism values. If the distinction drawn by the Lopez and Morrison cases and the standard established by those cases is ineffective and incoherent, is this something that you could and would employ as a judge?
Senator, as with all of the Supreme Court's precedents, absolutely. I mean, I would faithfully apply that standard under the guidance and instruction of the Supreme Court.
But what if it's incoherent? Then what do you do?
Well, Senator, I think the court actually grappled with that very issue in the subsequent case, the Gonzalez versus Raich case, where they were posed with I think, a similar characterization issue as to whether or not marijuana grown and used for medicinal purposes purely within local boundaries qualified as a kind of activity that could be reached under the Commerce Clause. And there, I think the court made an accommodation. It said that though this is non-economic activity, it belongs to a class of economic activity. And so I'm not sure exactly where that leaves us, but the rule that emerges from Raich seems to be that non-economic activity that belongs to a class of economic activity is reachable under the Commerce Clause. And so I think that the only point of the book was to suggest that definitionally these things, like all distinctions in the law, when you press very hard on them, there are gray edges on the distinctions. But in the main, I think these are workable in the role that I would be filling if I were confirmed.
So in the wake of Gonzalez versus Raich, and setting aside for a moment the exceptions identified in Lopez and Morrison, can you identify limits on federal authority that exist outside of Lopez and Morrison?
Well, Senator, it would be difficult for me to present a hypothetical, given that one never knows when an issue will actually be litigated. But let me try to answer your question by saying that my own understanding of this area begins with one basic supposition, which is that the federal government is a government of limited power. The very enumeration of Congress's powers in Article 1 presupposes that there is that limit, and the 10th Amendment to the Constitution makes that explicit. It says that all powers not delegated to the United States by the Constitution nor prohibited to it by the states are reserved to the states, respectively, or to the people. And from Madison to Hamilton to the precedents of the court that follow, every one of these sources confirms that basic proposition. And so any judge that approached a Commerce Clause question would have to yield an answer to a problem that was consistent with that fundamental bedrock proposition of our system.
Okay. So getting back to your statement that the distinction between economic and non-economic as drawn in Lopez and Morrison is ineffective and inefficient, is there some other way that you could have reached the same result in those cases without drawing the economic-non-economic distinction? Either as to bare non-commercial gun possession at issue in Lopez or acts of violence at issue in Morrison?
Well, I think actually the opinions themselves provide some guide to that. As I recall, the Lopez case was just simply did not indulge what it said was the sort of piling inference upon inference in applying the substantial effects test of the doctrine. So part of one way to read Lopez, I suppose, is to say that the court is simply unwilling to develop a chain of reasoning from mere possession of an article of commerce, to be sure, but the mere possession itself is not economic, to the economic effects that were posited by the dissent. And that was simply too distant in the chain of linkages to get to a substantial effect.
In a 2008 Stanford Law Review article, you wrote, quote, "The problem for courts is to determine at the moment of decision whether our collective values on a given issue have converged to a degree that they can be persuasively crystallized and credibly absorbed into the legal doctrine. Can you tell me how a judge discerns when, whether, to what extent a particular value has been persuasively crystallized so as to become part of our law?
Well, Senator, I think that in some sense, I think that that's a kind of, what I wrote there is a unremarkable observation about the way the Supreme Court elaborates doctrine. So just to go back to the Fourth Amendment examples I was providing earlier to Senator Feinstein, what constitutes a reasonable expectation of privacy? Well, the court undertakes, I think, an objective analysis. It doesn't ask what they themselves think is a reasonable expectation. They ask what society thinks, and I think that the cases are very clear that the inquiry is whether society has developed a legitimate or recognizes a legitimate or reasonable expectation, and I think they look to whatever indicators that they can. In the practices, in the case of the text messaging I was describing, they look to certain practices of employers and the expectations of the employees, and they may look to the case law as it has developed in the state courts and the federal courts. And so this happens, I think, all over the constitutional jurisprudence as elaborated by the Supreme Court. And so I think this is, in some sense, kind of a banal observation about the way the court elaborates doctrine.
I see my time's expired, so we may be able to get back to that
Thank
later.
you.
Thank you very much, Senator Lee. Senator Coons.
Thank you, Professor Liu, for